there is going to be capital gains tax, there will be transfer duty, there will be transfer fees. And so what's this Section 7C loan trap that I speak about? So what this is when people were trying to do structuring, so instead of moving the assets directly to the children, they move the assets to the trust for the benefit of the children. So it almost feels like it's the same thing, right? But in our law, it isn't, because a trust can be its own taxpayer, right? And now Section 7C, when people started seeing that individuals were doing this, why would they do this? Because a trust doesn't always pass away. So under certain circumstances, you can avoid paying estate duty if you move things into a trust, because at least then it sits in the trust. And when you pass away, the trust doesn't pay any estate duty. So what SARS did in these instances, because people were now actually donating to the trust, but not paying donations tax, so we're doing it by way of a loan account, and SARS wasn't getting its cut, right? What started happening now was SARS introduced legislation that requires donations tax to be paid on the interest that should have been charged, but might not be, or the portion of the shortfall. So there's a prescribed interest rate on the loan account that SARS expects you as a seller to charge. If you're not charging that full interest rate, whatever you're failing to charge is going to be counted for donations tax. Now, this sounds okay because it's often immediately not as high as the donation tax on the full amount, but the downside is it accumulates over the years.